Hi everybody, April Jones here. I have been an attorney now over 33 years, and Jones Law Firm has been serving clients in Colorado, and we are in our 24th year. This webinar series, I'm so excited to bring it to you. It's helping us with our mission of education, enlightening our clients, and really helping you try to get to the next best place in your life. So we've got a lot of good information for you. We've got experts, we've got our team, we've got panel discussions, and so much more. So let's go see what this webinar is about, and I will see you on the other side.
Hello, everyone, and welcome to our webinar on child support versus spousal maintenance, key differences and how they work together. My name is Haley Hollins, and I'm glad you could join us today. These can be confusing and often stressful topics, so we are here to guide you through what each one means, how courts decide on them, how they might work together in your situation, and we've got a great panel here today to help guide you through these topics and answer your questions. Please do feel free to submit your questions through the Q&A feature, and if we've got time, we'll ensure to answer as many as we can. So before we get started, I'd like to have our panel introduce themselves. I'd like to start first with Attorney David Collins.
Good afternoon. Thanks for joining the webinar today. My name is David Collins. I'm a senior attorney at the Jones Law Firm. I've been practicing law for 20 years in Colorado. I do all aspects of family law, including divorce, parenting time, grandparent visitation rights, guardianship, step-parent adoption, protection orders, and anything related to issues between folks who have shared a child or who have interest in a child. Thank you.
Thank you. And John, would you please introduce yourself?
Yes, good afternoon and welcome everyone. My name is John Dugan. I've been practicing law for 13 years now, and I practice in the area of family law, all aspects of family law, and I also do probate as well.
Thank you. And Will.
Hi, I'm Will Garvey. I've been an attorney for 5 years now. I practice in the area of family law, kind of all areas of that. And I also do some estate planning and a very small bit of civil practice as well involved.
Wonderful. And I don't think I introduced myself beyond my name, but I am Haley Hollins. I am also a senior attorney here at Jones Law Firm. I've been practicing family law in Texas and then now Colorado for a total of 8 years. And I just wanted to say thank you to all of our panelists for being here today. So let's jump right in. So David, can you tell us what exactly is child support and, well, do courts require it?
Thank you, Haley. And that's a great question. And courts do require it if a child is involved. It's something that will be calculated in every case where two parents are seeking court orders for the allocation of parenting time of a child. The parties are required to provide financial information to each other. And if they go to hearing, they'll present evidence to the court. But most cases for child support can settle between the parties once they've exchanged their financial information. But child support is meant to provide the quality of life the child would have had the parties stayed together. And not every child support case involves people who are married. We have plenty of child support cases with people who are just boyfriend, girlfriend. We have child support cases with people who had a fling and had a child together. But in any case, if two parties have had a child, the court, as part of any proceedings for parenting time, will order child support. In addition, either party, without ever filing a case for parenting time in court, can simply seek child support through the juvenile court in their county or through their local county Department of Human Services. And again, it's meant to support the child. And so in general, and we'll get into this, the questions you can ask later, the party earning more, and in particular, substantially more than the other parent, is likely to pay child support. But that is impacted by other factors. The biggest one is where the child lives and how often.
Thanks, David. And so, Jack, can you kind of give us the other side of the coin? What is spousal maintenance and how is that different than child support?
Certainly. Thank you for asking. Spousal support is when one spouse, after the divorce, has to pay another spouse. And the reason being is to equalize things, to make sure that the parties not necessarily maintain or have the lifestyle they enjoyed during the marriage, but come very close to that. So it's kind of fair and reasonable. And it's based on the time the party's been married and the incomes. There are several other factors that are considered, but generally speaking, that's what we look at. When you compare it to child support, there are some key differences. Child support is mandatory. Judges can deviate from the amount that's been awarded pursuant to the guidelines. But maintenance, on the other hand, can be waived. Both parties can agree that they don't want to receive or pay maintenance, or they can modify it and make it more than what the statute allows for. So there's a lot more flexibility, and you can also pay maintenance in bulk, which is something that is not necessarily, is pretty unique to maintenance, and a way to kind of alleviate that responsibility all at once. So there are some very key differences when you compare the two.
That's a really good point about the lump sum payments. They are very similar, I think, in people's minds about ongoing monthly support to an ex-spouse, but there are a lot of minutiae there between how they're paid and what they're payable for. And so, Will, a question to you. So if you get a general question from someone that they ask, will I be required to pay both child support and maintenance? How do you respond to that question? I know it's a pretty technical one.
Well, I'm going to give the answer I've given on many webinars before, and the lawyer's favorite answer. It depends. If you have children and you are getting divorced, you've been married for over 3 years, talk a little bit more about that 3-year threshold in a little bit. But if you've got a child and you've got a spouse, most likely you are going to be paying both child support and maintenance. It's also going to be income dependent, like both Jack and David have mentioned. It really is just going to depend on the situation. You're going to be paying that child support for up until the child turns the age of 19. There are some circumstances where it could be less if the child goes off to college. It can cut off at the age of 18, but you're likely going to be paying both unless you come to some sort of agreement to waive the maintenance, as Jack was talking about, or you can waive it in exchange for other assets. And that kind of works into what that lump sum kind of payment would be.
Yeah, and kind of a follow-up to you, Will, on that. Do the payments interact at all? If I'm paying a lot in child support, does that lower my spousal maintenance obligation at all?
So yes, it will. The court will factor that in when looking at both maintenance and child support. It's not going to reduce the child support side of it, but it will reduce the maintenance side. Something interesting about child support, people often confuse this. It's not really owed to the spouse. It's owed to the children. That's why it can't be waived in these situations. You don't really have the ability to waive paying child support or receiving child support on behalf of your children. Because as David was talking about, it's meant to kind of put the child in the same position had the family not been split up.
No, and then that makes sense. So, David, I'd like to come back to you. Can you talk to us generally about how child support is calculated, what the court looks at, what the court takes into consideration there when coming up with that figure?
Sure. And I'll just correct Will, and I apologize. The child support and maintenance are two sides of the same coin in family law court. Maintenance will be calculated first, and then child support. The reason is that for example, if the husband is paying the wife maintenance and he's paying her $4,000 a month in maintenance, on the child support worksheet, that is added as income for the wife. And then the child support calculation includes maintenance the party receiving it gets as their income for child support. So often, if you have a marriage where the children are, say, 10 years old and the marriage was 10 years long, you might be looking at 4.5 to 5 years of maintenance. During that time, if the ex-husband was paying the wife $4,000 a month, that would be in the wife's column for income. For that reason, child support might be lower than when maintenance stops and ex-wife is no longer receiving that income. The child support will then go up. So the parties are going to end up recalculating child support when maintenance ends. To calculate child support by itself, the two primary factors are the incomes of the parties, and that is the monthly gross income of the parties, not net, and then the number of overnights each party has with the child. So on a 50-50 parenting plan, each party has 182.5 nights a year with the child. That is 50-50, and that's how you get to the lowest child support payment you're going to get in any situation. If one parent has more parenting time, then child support is going to go up for the parent that doesn't. So if mother has the child 75% of the time, that is going to significantly increase the amount of child support that father is paying. There are other factors that affect child support. If one party is carrying health insurance for the child, the credit for that goes on the worksheet, and that credit is really divided in proportion to income to the parties. So if wife earns $5,000 a month and husband earns $10,000 a month, uh, husband's responsibility towards insurance is higher in whatever the percent, whatever percent 10,000 is of $15,000. That's husband's obligation towards the insurance. So if mother is providing the insurance, then father has that obligation in proportion to his income, and that would increase child support for father because mother is paying the insurance. The same principle applies to childcare. For work-related expenses, it's almost impossible to go to work every day and have children unless you have childcare. And that's because we work generally from 9 to 5, and school goes generally from 9 to 2 or 9 to 3. And we have to get to work and get our kids to school. So parents have before and after care often that they pay for, and that would be work-related childcare for the children. Summer camp is the same. If you have to work all summer, which most of us do, then you may be able to count the summer camps that they go to all summer long or summer programs as work-related childcare.
Thanks, David. And so, Jack, I'd like to come back over to you and talk. And so, if someone comes to you and says, I just got married 2 months ago, but I'm worried that my ex is going to ask me for alimony, for spousal support. I want a divorce and we haven't been married that long. How long does someone have to be married for the court to consider awarding spousal support or to have that as an exposure if they're thinking about getting a divorce or litigation?
No, and thank you for asking that question. And I mean that because it's a fun one to answer, because oftentimes clients do come in with all these preconceived kind of notions and some Google research as to how alimony or spousal support or maintenance would be applied in their situation. And they have all these kind of thoughts and ideas that oftentimes are incorrect. So it's good to always be able to put them back on track. Very satisfying to do that. So after 3 years, those maintenance laws come into play, and that's when they come into consideration. With any law, there's always exceptions to the rule. One that I can think of, whether it be a prenuptial an agreement or a marital agreement, where there'd be some sort of provisions where maintenance would be applied prior to the statute requirement. But generally speaking, it's 3 years. So like I said, those are always good consultations to have with clients and let them know, because that's often a big fear for people that get into those situations where they want to get out quickly.
Absolutely. And I think that's important to know and to think about. And Will, I think you touched on this a little bit earlier. On the other side of the coin, what about child support? How long can someone expect to be paying that?
So the statute defines it until the child reaches the age of 19. So even all the way through being 18 years old, you'll be still making those child support payments. Again, there's exceptions to that. One, if the child goes off to college, it starts at 18, so it will cut off once that child goes to college, but there'll likely still be some support going directly towards the child, and maybe in the forms of paying for college or paying for some of the boarding or books or anything like that at college, any of the expenses that kind of go along with that. Another instance where it can be cut off is if the child is emancipated. We don't see that too often in cases, but it is something to keep in mind. If the child gets emancipated at an earlier age, that child support payment can cut off sooner.
And so, David, I've got another question for you. So if a client comes to you and is concerned about their immediate making their minimum reasonable needs to kind of pay for things during the pendency of the case, is something like a temporary spousal support an option before you get to a permanent order? How would you advise a client who's worried about that?
Yeah, thank you. And that is a great question. And yes, parties can ask the court for a temporary orders hearing. The parties can stipulate to temporary support, and sometimes they do. Often, if both sides have counsel, they'll get advised by their attorneys that, look, if you go to temporary orders, it's likely that you'll be ordered to pay temporary support, depending on the facts. And so they'll just negotiate that. But if the parties can't agree on temporary support and for payment of attorney's fees, either party can ask the court through a motion to hold a temporary orders hearing to establish temporary support. And that's important because in some counties, the docket is so backed up and so busy that you might not get to a permanent hearing for 12 months or more, even if everything has been done timely in the case. The court's dockets are just backed up. Another thing that can slow down a case is the hiring of experts. Sometimes the parties want to have an expert weigh in on parenting time. Sometimes they want to have a business valuation come in and value a business a party owns. or maybe you think there's nefarious activity, so you want someone to do forensic accounting in a case, and things can delay a case. And the longer it's delayed, the more you might need support. Now, the wrinkle there is you're probably unlikely to get temporary maintenance and child support if you live under the same roof as the person you're seeking support from. If it's the only way you can liberate yourself out of the house, the court might award that. But in that situation, the court is going to look very closely at the resources of the parties and decide whether it's in everybody's best interest to pay for two separate households during the pendency of the case and whether they can actually afford that. But for parties where it is possible for them to separate during the proceedings, for one party to move out of the house, it's really appropriate to establish temporary maintenance and child support.
Excellent. Thank you, David. So I'm going to shift gears a little bit. We've received some viewer Q&As or participant Q&As that I would like us to be able to answer for the folks who are here today. And so I'll go ahead and I'll answer the first one myself. I'll read it. Is that this person's soon-to-be ex has cheated on them with their best friend and have decided to keep that relationship going amidst the parties' divorce. Their question is, if my ex-spouse remarries or starts making more money, can I stop paying spousal support? And so my first question to this person would be, before answering this, would be, are you divorced and do you have an order to pay spousal support? It sounds like amidst your divorce that there may not be permanent orders yet, because what I'd be looking for as the attorney answering your question would be to go to that order and read those specific terms. Sometimes the courts order payments that are division of your estate, kind of an equalization payment that you might be paying out monthly that isn't an actual spousal support payment. But if you are paying a monthly ongoing spousal support payment, we'd want to look to the terms of your final orders to see what provisions apply for that termination to occur. But all that to say is that if your ex-spouse remarries or starts making more money, what the court would be looking for if you ever filed to modify those terms would be if the original award was substantially unfair at the time it was rendered. It's usually not something the court's going to grant unless the circumstances have changed significantly, would be my take. But first and foremost, it would be important to consult with an attorney and to bring your actual order so that we could evaluate that and review your options with you. All right, I've got another question. I think I'm back to Jack. Is that right? I'm
Correct.
going in order here. Okay. All right. This next question is from a viewer who has asked if there are any legal tools or options to consolidate or simplify these payments of child support or spousal support to avoid financial strain. So it sounds like someone who's asking about other ways to structure or get relief from these payments that may have already been ordered that are causing them to maybe not be able to make some other payments.
Yeah, certainly. And it's always good to, review those things. And if there's been any change in income to consider, has there been a change that would trigger any change in the amounts of maintenance or child support that you would have to pay? So those are both very good things to consider. And online, there are great tools to go ahead and use to see if maybe those numbers have changed. Contacting our office or any attorney really to find out if they can run those numbers to find out if there's been a change. If there has, and it's been a substantial change and there's been a significant change of greater than 10% of the income, you can ask the court to change both amounts, to modify both amounts to be reflective of the true dollar amount that you make now. The one kind of backside to that, or the other side to kind of think about and consider is, especially if this is opposed to decree matter, you might not know what the other party's income is. So it could be a situation where you don't exchange a whole lot of information. Your income is decreased. You might want to try and file a motion, but at the same time, you're not quite sure what the other party's income is at the time. So if it's lower, it might be a motion that you might not be successful on. So it's good to have as much information as you possibly can. As far as, just thinking about this question from different perspectives, as far as consolidating payments or making one payment to one person, and rather than, if you have to make a child support payment and a maintenance payment, that can be really challenging. I understand that. It really depends on the flexibility of the person receiving the funds, if they're willing to consolidate to one day or divide the payments to structure them based on maybe payroll or something to that effect. You can always try and ask the court for that type of change. If it's reasonable, you might have some success, but you always should have a good argument and try and resolve those things prior to going to court. Those are the little things that you can sometimes resolve without the need of attorneys. It's a matter of just trying to reach out to the other party and see if they be willing to modify anything. And if you do modify anything, make sure it's written, signed by both parties, and something you can file with the court. That's very important.
Excellent, thank you. And to Will, we have another viewer question. This person has asked, and this is a very realistic situation that I think most of us see quite a bit, is what happens when a father is untruthful about his income because he makes more money than he's claiming, and also that he's saying that he wants to have equal parenting time to reduce his child support obligation to the mother. What kind of advice would you give to a client who's concerned about, first, the money not being disclosed as it should from his income, but also for someone who might only be asking for equal parenting time for a discount? What are your thoughts there?
Yeah, I mean, this is a great question. This is something I know I encounter all the time myself. I know the rest of the attorneys here encounter all the time. This can kind of be viewed through two lenses. One is you've got an ongoing divorce case, and two is you're moving to modify child support after a decree has been entered. Why don't we start with the first one? So during a divorce case, one of the first things you do after filing a petition and trying to get the divorce process started is having to issue your sworn financial statements. That's kind of an overview, broad picture of what you earn in a month, what your expenses are, what your debts are, what your assets are. That happens in every case. You always have to do this. Unless I guess you settle early enough, but the courts sometimes won't sign off on the decree unless there's been a full and complete disclosure of finances. So for the most part, you're going to have to turn in, your most recent pay stub, your 3 years of tax returns, bank statements. So you'll be able to get an idea of what money is coming in and going out. It gives you a good idea of what someone's monthly income is. If someone's in, a 1099 job, a W-2 each year, it's going to be fairly easy to track what their income is. We run into situations that are difficult sometimes when people own businesses. They may pay themselves a very small amount, but take partner draws. They may try to hide income through other things. In those instances, discovery is going to be a useful tool to try to uncover what information or what income that person is actually earning. If you get the finances for that company, you can go through expense reports and say, they're buying dinner for themselves these nights of the week. They have a company car where they're paying for gas they're using for personal use. You can take all of that together and add it up and say that actually is that's more accurate reflection of what their income is. They might pay themselves $25,000 a year, but their company might generate, $200,000 in profit. And they expense everything for their entire life through that business. You would add up those expenses together to try to get a more accurate version of what their income is. That's easy to do while the divorce case is still going on because you have the tool of discovery available. Post-decree modifications, discovery is not always available. You'll have to request the ability to do that from the court. You can always request updated financials. You can get tax returns for later years to show what their total earnings are. But again, if they own their own business, it can be difficult to try to get a full accounting of that. So then the discovery really will be necessary to go through that entire process. And then also another part of that question is the father wanting 50-50 so that he has less of a child support obligation. That can be a bit of a tricky situation. Courts are always very in favor of having both parents fully involved in the lives of their children. 50-50 is kind of where everything is going to end up, unless there are circumstances that would make it more appropriate for, say, the mother to have a 60-40 or 70-30 type of split. Situations where you'd see that is if the father works a whole bunch and isn't going to be available to pick his children up and drop them off at school all the time. The court might be more in favor of having a 60-40 type of situation where the father has children on the weekends. If it's just weekends, that's something closer to a 70-30 type of relationship. I know David talked about earlier, the number of overnights is the calculation. And correct me if I'm wrong, but I believe 92 overnights is kind of that minimum number that you have there. Once you're below 92 overnights, you're going to be paying the maximum amount of child support. And I do see that often, that one parent fights for 50-50 just so they're paying less in child support. Many options to try to rearrange that. If that's the case, you can hire a CFI or a PRE, a child family investigator, or a parental responsibility examiner or expert. I always forget how that acronym comes out. But it's someone who comes in and examines what would be in the best interest of the child, or who should they be living with, who is going to be more involved in their schooling, their day-to-day cares. You can see that through decision making, because decision making can also be broken down through schools, medical, religion as well. So they can come, those experts can be useful in determining whether or not 50-50 is going to be in the best interest of the child or a different type of arrangement.
Excellent. Thank you, Will. And to David, I've got another viewer question. The listener viewer, they've written in and said, I'm worried about paying child support and how paying for it will impact my ability to afford things like vacations with my kids or buying them gifts. What can I do? How would you?
Well, it depends on how, child support is really dependent on the income of the parties and the number of overnights they have. If you are the higher earner and you're on an equal parenting plan, you're likely to pay child support. There is no way out of it. So there's no out of child support. The parties can agree to zero child support, but they can't agree to zero child support forever. Any party at any time can seek to modify child support if child support would change by 10% or more. If you're paying $500 a month in child support, a $50 change would warrant a motion to modify child support. So if you agree today to zero child support because the parties say, you know what, we don't need it, and parties do that. We have parties on a regular basis who agree they're entitled to some amount of child support. Maybe it's not much and they just agree not to have it. But we have to advise our clients, you can't permanently waive child support. By statute, the court reserves the jurisdiction to change it at any time. Unfortunately, divorce is expensive, and not just the process of divorce, but living in a single parent household after divorce is expensive, especially if you're paying money out of your single household income to the household that you just divorced. But that is the case, and there's no way around it. If you're ordered to pay maintenance and child support, you have to pay it. If you don't pay it, it will accumulate against you, and the entry of judgment can be obtained, and liens can be put on your property and your bank. And I say all these things not to scare you, but also to scare you, because you have to know the consequences of not paying the support you've been ordered. And so the answer to the question is you're going to have to live with less. You may not be able to do all the things you've traditionally done. And it depends on how much you used to traditionally spend and how much you're spending every month in child support. If you're paying $1,000 a month in child support, which is possible, that's $12,000 a year. And that's after deductions from your paycheck, right? That's net income that you're paying from. That's a big deal. And so that could impact the lifestyle you have in your own home.
Thanks, David. That's a very realistic answer. And to Jack, I think this question kind of rolls into that, insofar that this person is worried about asking for spousal maintenance because they're worried about it'll cause more conflict with their soon-to-be ex. How would you recommend or advise someone approach that conversation without making things worse between the two of them if they're on a shaky ground?
Sure, this is always a challenge where you're on pretty decent terms with the ex and things are working really well, but there's an increased need, or there's a need for more support. Having that difficult conversation and thinking that might have a ripple effect downstream with the relationship moving forward. So that's a very oftentimes a question we have with clients when they come in to speak about these changes and how do you do that. My suggestion is communicate in ways that you have before. And don't try and do things that are too strange from what you've been doing in the past. Don't deviate from the norm. So if you typically have phone calls with a person, yeah, unfortunately, you won't have that information to recall. You can maybe always follow up with an email, but don't try and seem like you're trying to set things up for a later day in court, because that could happen and really kind of blow things up. You don't want to do that. Have that conversation, see if you can initiate things and see where it goes. Try and get it done without the use of the court system, but know that we're here. Our firm is here to help you get through that. If that's the next step in your case, we can certainly support you in that and help you with that. Again, it's always a cost benefit analysis doing this thing, engaging with lawyers, even making the determination of whether or not you want to go ahead and ask for this increase in support, which you're totally entitled to, but is it worth what it will cause? That rift in the relationship, is the spouse helping you out in other ways that's maybe off the agreement of the parenting plan that might cause some other issues. So something to really think about, is it worth the money? Of course, I would never tell a client that you're not entitled to what you're owed by statute, by the law, but at the same time, it's a balancing act there.
That's incredibly fair. And we've got just one more live question that I'd like to answer here just before the end of our time, which is that an anonymous attendee asked us, what about income from a second job? I believe whether that's included in your calculations for child support. And to go ahead and answer that one is that the statute indicates that a second job beyond 40 hours per week of work should not be included in your child support calculation. However, there are certain caveats that income derived from additional self-employment or business ventures could be included. So it's important that if you're self-employed or have multiple sources of income, to have that evaluated by an attorney who can advise you specifically what should be included or excluded from your calculation. And with that, I would like to thank everyone who registered and attended this webinar and those that submitted questions, and to my fellow panelists. Please, if anyone who's listening to this, call the firm and reach out to us if you need any help with child custody or any other family law issues. Be on the lookout for our future webinars in 2024 that are on the second and fourth Wednesday of every month. We cover a variety of topics on these, and we look forward to seeing you there. Thank you again for attending.
I hope you enjoyed this episode of our webinar series. You can reach us at denverdivorceattorneys.com. You can call us at 303-799-8155. We're on Instagram, Facebook, Twitter, TikTok, LinkedIn. You can find us if you need us, and we're here to help. Thank you, and see you next time.